I'm Drew Stevenson. This is for my administrative law class. And here I'm going to be talking about a case called New York Legal Assistance Group versus the Board of Immigration Appeals, or BIA. This is a Second Circuit Court of Appeals case from 2021 about the Freedom of Information Act and affirmative disclosure rules, or the requirement that an agency has to make certain information public or available to the public without even being asked. So let's dive in. So, the vast majority of decisions that are made by the Board of Immigration Appeals every year are unpublished or non-precedential opinions. And so there are tens of thousands of these every year. NYLAG, the plaintiffs in this case, are basically legal aid lawyers who would represent immigrants before the BIA, and they wanted access to these because the government lawyers in immigration cases did have them, could search them, find relevant cases, and cite them as persuasive authority in support of the government's case. And the lawyers representing private individuals were unable to do that and thought that these should be made publicly available to everyone. So the question on appeal was the scope of FOIA's remedial provision, which is in 552A4B, and specifically whether it authorizes federal courts to order or compel agencies to make some information available to everyone in the public, so let's say through their website, as opposed to just disclosing information requested by an individual claimant to that claimant. And the plaintiffs here, they wanted the former. They didn't want just the BIA to turn over thousands and thousands of cases to them for the sake of one client. They wanted to force the BIA to make the information publicly available up till then and going forward so that it would be searchable and available to lawyers who are representing people before the BIA all over the country from then on. In this case, the district court had actually dismissed the complaint because the district court read the remedial provision in the statute as giving the court authority only to order that information be turned over to the complainant in an individual case or to one person, as opposed to compelling an agency to make information available to the general public. There was actually a circuit split on this issue between the DC Circuit and the Ninth Circuit. The DC Circuit had taken a more restrictive approach, and basically the idea that courts can only order the government to turn over information to an individual litigant, whereas the Ninth Circuit had taken the broader approach to the statute and held that agencies could be forced to make information available to the general public, such as through their website. The Second Circuit in this case decided not to follow the DC Circuit's narrower approach, and it really had two main reasons for that. The first was that in that DC Circuit case, both parties, both the private litigant and the government, had basically agreed that that the information only needed to be turned over to the party in the case. So the court wasn't really being asked to make it publicly available by the parties. And secondly, that there was a prior precedent in the DC Circuit that the court thought that they should, or bound by, or should act consistently with. And that wasn't true in the Second Circuit. So the court here decided to follow the Ninth Circuit's broader approach, and they did so partly for a statutory interpretation reason that I want to talk about because this involves a rule of thumb or a canon of construction that comes up quite a bit in administrative law. And the idea is that when courts have a relevant text, let's say the clause in the statute or the subsection of the statute that's disputed or at issue in the case, that it doesn't make sense to interpret that in a way that sort of cancels out the rest of the statute or makes other provisions in the statute just redundant or repetitive or superfluous, as the court says here. The traditional name for this is the canon against surplusage. And that's the approach they took. They thought that interpreting the statute narrowly this particular provision would make other clauses in the same statute essentially meaningless or repetitive or redundant. And so uh, just be aware that this is an issue that comes up. The meaning of the relevant statute that controls the agency often ends up influencing the court in deciding what the court itself is allowed to do. So, continuing with this idea of focusing on the statutory verbiage in this case, the court analyzed Section 552A4B and concluded that it actually grants courts two separate and independent powers. The first is to, quote, enjoin the agency from withholding information or agency records. And the second is a separate and distinct power to order the production of agency records that are improperly withheld from an individual complainant. The DC Circuit had kind of conflated these, and the Second Circuit here in this case decides that they're going to interpret the words of the statute to create two separate things or two separate powers that the statute gives to the court. Even apart from the statutory verbiage, the court looked at the broader statutory context or structure here and said that the broader statutory framework reinforced its conclusion. It indicated that Congress had intended and anticipated that there would be judicial orders that compelled agencies to comply with proactive disclosure requirements. In other words, the courts would be able to order agencies to proactively or preemptively make information available to the public even without being asked. And that the narrow reading of the statutory provision that was urged by the Board of Immigration Appeals in this case would basically have rendered some of the affirmative disclosure requirements in 552A1 and A2 as merely precatory or basically toothless if there was no enforcement mechanism in the statute. The Freedom of Information Act had passed or been enacted originally in the late 60s, but there were some amendments in 1974 to the statute. And the court also looked to the amendments for guidance about meaning. In other words, the idea is if Congress amends a statute, that the amendment suggests some things about Congress's goals or how they want the statute interpreted. And the 1974 amendments seemed to clarify or reinforce that there would be judicial review available for agencies that withheld information under any provision of 552A. And so based on that, the court said that should apply to this type of case too. So we've talked about the statutory verbiage, we've talked about the sort of larger statutory structure or framework or context, and also the inferences that can be drawn from the history of amendments to the statute. The court, though, also looked at the statute's overarching purpose, because sometimes that can give courts guidance in interpreting ambiguous individual phrases or clauses. And here it's pretty clear that FOIA's fundamental purpose is to facilitate public access to government documents and information, or, quote, to open agency action to the light of public scrutiny, to prevent a system of secret agency law, and where the government lawyers have private information about what has happened at previous hearings and previous decisions by the agency or administrative law judges or hearing judges, and the public doesn't. So in terms of the holding in this case, the court reversed the lower court, the district court, and remanded the case for further proceedings and consideration under this decision, basically because it had concluded that Congress did intend to give courts the authority to order agencies to make certain information publicly available. I know some people like to underline or highlight in their casebooks, and I wanted to direct your attention to a really good Zinger quote that I think is part of the crux of the court's opinion or holding here. It said, "The text of FOIA's remedial provision and the 1974 amendment to it, considered in light of FOIA's history and purpose, make clear that Congress gave courts the authority to enforce an agency's obligation to make certain documents publicly available. So, what happened after this? Well, the parties settled after the NYLAG won at the Second Circuit. They made a settlement agreement that required the Board of Immigration Appeals to post nearly all its former opinions on a publicly available website that would be indexed and easily searchable. This is a lot of opinions. We're talking about maybe 30,000 per year. Now, even though the NYLAG versus BIA case is a winner for advocates for government transparency, sadly, it's also an outlier. In a lot of these cases, it hasn't gone this way. The government has won, and there have been multiple audits of various government agencies over the years that consistently show poor compliance with the rules that require agencies to make a lot of information publicly available. In the old days before the internet, they were supposed to have print copies of all of their archives available in something called a reading room that was sort of like a library or a reading room where you could go and check documents out and read them or copy them. And now with the internet, things are supposed to be made available online, and some agencies are better about it than others. But overall, there are a lot of documents that agencies have that they are supposed to make publicly available, and they are not yet publicly available. So, wrapping up here, that brings us to the end of this quick overview of the New York Legal Assistance Group versus the Board of Immigration Appeals. Thank you for watching.